All right, everybody. I know that due to weather, and I'm sure some of you have clear roads or could be on campus already, but in the interest of everybody, I just thought I'd try to make it easier and safer just simply by making this video. And I will try to make it to where, like I said, I can cover this material in about two videos, I'm hoping. So either way, let's get going. Last time we had class, we are talking about the different aspects of what everybody does in court. And in fact, a lot of it, after going back over some things, is stuff that you should have already covered in Survey of Criminal Justice, LAWE 100. So I will spend a little bit less time going over some of these things than I originally planned. So continuing on with what a judge actually does, as you can read here, they preside over the court. There's such thing as bench trial. There's also en banc, which is also a different type of bench trial. So regular bench trial just has one judge. En banc includes three. Most of the time for bench trials, they are for misdemeanors as opposed to some of your felonies, things like that. In addition to that, anybody who is charged with a felony, for example, in some cases they can ask for their rights to be waived for a jury trial, because that in essence is a right that people have. But if you want to waive that to make it more expedient, in essence faster, what they will do sometimes is go ahead and waive it and say, I don't want a jury trial, I want to go ahead and just have a judge hear the trial. So that's one case, one situation where judges will hear cases without a jury present. Additionally, there can be courts of limited jurisdiction, which we can get into later today. Deals with things like drugs, alcohol, DUIs, sometimes other cases, family court, for example, would be another area. So those are courts of limited jurisdiction. But otherwise, it's going to be a jury trial for felonies. This is where you can have, like I said, the judge is responsible for deciding what evidence gets excluded both before a trial, but also during a trial, if evidence is discovered, for example, or any time that they are sharing evidence between the prosecution and defense. That's another area where the judge can decide what's going to be admissible in court and what is not. All right. Also, when it comes to what the judge will tell the jury is things like, okay, lesser included offenses, meaning, yeah, there may be a charge of, let's just say, murder, but there are also other charges along with that they are having to decide upon. So it's not just a guilty, not guilty sentencing for one particular charge. It'll be for multiple charges. So they may not be guilty of murder, for example, but are they guilty of any of the other lesser offenses? So that's something that the judge will explain. Additionally, the judge, when someone is on a jury, the judge, it's their job to explain what the burden of proof is. So, in terms of civil court, it's the preponderance of evidence, meaning more than likely. Okay, but when it comes to criminal, it's beyond reasonable doubt. Beyond reasonable doubt is the easy way to look at it. Some people say, oh, it's 99%. And it's nothing like that. It's simply saying, is it believable enough, or is there enough evidence to show that there is no other reasonable, rational way to explaining it? Or is there anybody else that we could, once again, reasonable or rationally decide someone else could have done it, whatever, right? Yeah, you can have some harebrained ideas or some crazy idea. That doesn't mean that that's going to be considered reasonable doubt. So you'll run into some problems. We'll talk about how this creates problems as far as what jurors and how it can affect outcomes of trials later on. Okay. Standards of defense. We can always talk about. The judge will explain this. If this particular defense is used, what elements have to be met in that sense. Okay. And the jury are going to go, so take a step back and talk about jury selection. You are going to be talking about what's called voir dire. So in essence, it's a selection process. Typically what happens is anytime that there's going to be a selection process, you bring in a pool of potential jurors. Both attorneys will ask, in the presence of the judge, both attorneys will be basically asking potential jurors questions, and depending on the answers to those questions, an attorney, whether it be for prosecution or defense, can strike or say, I don't want that particular person on this jury. So what we'll get into next are the different types of what we call challenges to that. So there are, I'll put both of them up here. There's challenge for cause and a peremptory challenge. Challenge for cause, as you can see here, is unlimited. If you can determine that someone has a specific prejudice, whether it be based on previous experience, life experience, if they were for example, if the case is a sexual assault or rape type of case, and someone has already been a victim of that crime or has family members who were victims of, say, rape, maybe if you are a defense attorney, you might want to strike that person from the case. If they already have a predetermined view on, say, the death penalty, if that's something that could result from this particular case, that's something that, say, the prosecution might want to remove from the selected jury or the jury pool. So, and those are, like I said, unlimited, as long as you can show that it's not based on just purely, say, race or anything like that. Now, what can happen is, with a challenge for cause, I determine that someone may have viewpoints that I think makes it tougher for me to win my argument, right? And I want to get that person off the jury. But if the judge doesn't see where that person has any prejudice that's noticeable, as I'm trying to explain, why they would be, why they may already have pre-existing prejudices. If the judge doesn't agree with that, basically the judge can say, nope, I'm sorry, I can't. That doesn't work. You can't use the challenge for cause there. However, what I can do in that situation is use what we call the peremptory challenge. And as you can see there, it's set number. But the key to that is, whatever that number is, and it changes from state to state. That's why I put set number. So let's just say I have 7. All right. And I originally want to use a challenge for cause against someone. That's not going to work. I don't have a strong enough case, if you want to call it that, right? I don't have a good enough reason to just remove someone from the jury, a potential jury, I should say. If that's the case, what I can do is use this peremptory challenge, and it basically is I can get rid of them pretty much regardless. The only thing that does put on there, you can't use race as a reason. So what some people have used before would be, say, once again, going back to that, say, rape case. If I have a female who I believe would be prejudiced simply because of, my client is a male who is being charged with raping a female or something along those lines, and I feel like that would not help my case, the challenge for cause may not be allowed, but I can use my peremptory challenge. And it does not affect, like I said, it has nothing to do with race, but maybe just the simple fact that I believe as an attorney, a female viewing this case might not view it fairly or neutrally, right? So that's when I can use a peremptory challenge, something along those lines. So without beating a dead horse, let's go ahead and move on. Talk about deliberation. It is a secretive, basically your jury, after you've heard all the evidence, all the testimony that we've already discussed, the different types of evidence, right? Once you've heard or seen all of that, you go into deliberation to a separate room, and the only people that are allowed in there would be the jury or the officer of the court, such as, some people might call it a bailiff, court security officer, something along those lines. And so obviously you go over or re-examine evidence, things that were questionable. And if you have any questions about evidence itself, or you'd like to see it again, if it's something physical to see or things along those lines, then you can ask the officer of the court to get that for you and bring it in. and you can re-examine it. If you have questions as far as say you're uncertain about different instructions or elements of a particular statute or law, uh, then you can ask the judge, and the judge will explain that in greater detail again. So as you see here, the judge will remind you to remain objective, but at times it doesn't matter, how hard or how effectively you try to do things objectively, and basically come to an agreement amongst everybody. So remember, this is a criminal trial, so therefore it's not say on a 12-member jury, it's not a vote of 9-3, for example, wins. It has to be unanimous agreement and decision. So you all have to come to an unanimous or the same conclusion about what you're going to charge this person with, whether they are guilty or not. Okay, and if that can't happen, whether it be one person or whether it be 5, if you can't agree on what the result should be, what the verdict should be, well, then you get what's called a hung jury. In essence, there is a deadlock. And the first thing that happens is the spokesperson for the jury tells the judge, in essence, hey, we can't come to an agreement. None of it, we can't say guilty or not guilty, and no one's budging. And the judge will encourage you to go back, re-examine the information again, and try to find some type of agreement. And if that can't happen, then they have what's called a mistrial. Okay, and in a mistrial, all that means is that there was not an agreement amongst the jury. That's all it is. There can be other reasons for mistrials. I mean, there can be misrepresentation by an attorney. There can be other reasons, but the main one you see the most is simply a mistrial. And usually what happens there is basically the judge will say, okay, it's a mistrial. We're going to try this again on a later date. So it's not that it's all over with or anything like that. It's basically saying this trial was ineffective, so we have to try again later with another set of another set of jurors to look over the material, and evidence. So that's all it really is for hung jury. But like I said, I already covered one other reason why it could be a hung jury. Some things I want to talk about would be jury nullification and jury vilification, but it's more of a focus on jury nullification. So I'm going to put both of them up here. And jury nullification, as you can read, is a decision that's kind of completely opposite of what the evidence shows. So a good example of this, even though if you go back in the 1990s, you have the O.J. Simpson case is what it was really called, but it was the actual murder of Ron Goldman and Nicole Brown Simpson. Okay, so even though the Los Angeles Police Department messed up with some of the evidence, and yeah, they lost some of it, they contaminated part of it, things along those lines, there was still what should have been ample evidence to convict O.J. Simpson of murder. However, what happened was at the time there were still issues with, say, racial issues out in Los Angeles. They had some riots previously, and then there were riots after the trial also. But what happened was, as you can read here, they ignore or misapply the law. So even though the jury knew what the laws were and knew that there was enough evidence to prove O.J. Simpson had murdered Ron and Nicole, basically they wanted to prove a point to the LAPD and say, we have an issue and we think you are a racist police department, so we are going to rule in favor of, which happened to be a celebrity, in favor of O.J. Simpson and acquit him of those murders. So we'll come back to that here in a little bit, but jury vilification is kind of the opposite of that. Is evidence doesn't warrant a conviction. There's not enough evidence there to convict someone, yet the jury goes ahead and convicts them anyway. So, I mean, it is similar to nullification, except the difference is nullification is typically considered not charging someone when they should have been charged with whatever the crime was. Not charged with, excuse me, should have been found guilty of. Clarify myself a little bit there. But vilification is finding someone guilty when, say, it was pretty much just circumstantial evidence as opposed to any real evidence that could have connected them to the crime. So hopefully you understand the difference between those two, and if not, you can ask me questions when we come back next week. But as for now, I'm going to finish that up. When I come back, I'm going to explain your assignment to you. You can read that yourself, but either way, I'll come back and finish the second video here soon. Have a good day.